My name is David Wilkins. I'm the director of the program on the legal profession. This is our weekly speaker series, which I'm delighted to see so many people here. I have to say, I was a little worried about what the attendance would be, not because the topic wasn't great, but because it was election day, and I said, oh, no, it's not just who Matt is. But I forgot, Matt knows everyone. And Matt has always known everyone. And in fact, that's how I know Matt, okay? So I met Matt when he was an undergraduate, when he was, I think at the time, the head of whatever the student government thing was, and he was on, we were both sentenced to spend 8 months together on a committee investigating the Harvard University police. You can imagine that was a fun thing to do. And in fact, just about the only thing that made it fun was that Matt was there every week, and he was always saying something interesting. He was always open to new ideas, and in fact brought the student perspective to a committee that was, after all, supposed to think about what this meant for students in a way that is rarely brought in these sort of, faculty-student things. We then got to know each other because, for various reasons I won't go into, he needed a few extra credits, so he wanted to write a paper, and he was always interested in law. And in talking about law, it quickly became clear to me that he actually knew way more about the Supreme Court than I did, okay? And I've been teaching here for 27 years. I still think that's probably true, but what's most interesting about Matt is not just, as many maybe undergraduates are interested in the Supreme Court for its legal decision making, he was interested in the Supreme Court for how it worked. And in particular, how the advocacy in front of the Supreme Court worked. And that's where we really connected, and what really connects with this program and what we're trying to do here, which is to try to introduce you to the way in which the legal profession is evolving. He has done some of the most important work on the question he's going to talk to you about. As an undergraduate or a recently graduated Harvard College student, he was already being published. He's worked at the Sundquist blog. He told me already this will be his 7th published piece, which would already put him pretty much in the spectrum of getting tenure at Harvard Law School, although never having yet gone to Harvard Law School, maybe never doing it. He's also working at Facebook. So it's going to be a tremendous opportunity to hear from somebody who's really thought carefully about one of the most interesting questions that's actually going to be decided in this election, which is not just who's going to be appointed as a justice of the Supreme Court, but also who's going to be in the Solicitor General's office, and who therefore is going to become one of the most important legal advocates of the most important cases that will be argued in front of them. So, without further ado, it gives me great pleasure to present Matt Scott.
I only sent over a 2 or 3 sentence introduction in hopes that I could keep expectations low. I now realize there's no way I'll ever live up to anything David just said. But thank you for everyone for coming, and David and folks from the center for generously supporting my very nerdy and odd questions about the Supreme Court. I'm also excited to see that Professor Lazarus is here, who has written what I think is the most fascinating and awesome paper that's ever happened about the Supreme Court bar. So feel free to cut in if I'm veering off course. The question that I am looking at most now is this idea of whether veterans of the Solicitor General's office have some type of undue or odd or unique influence on the way that Supreme Court jurisprudence happens, or other questions around how the litigation actually plays out. A little bit of background on this. First of all, the Solicitor General's office. So the general role of the SG is they're appointed by the executive, and they have this interesting position that's similar to the vice presidency in that they can be suspended between 2 branches because on the one hand they are appointed by and report to the executive, but on the other hand they have this unique role in the Justice Department. But they're an advocate and advisor for the executive, and then their main work involves defending laws that are passed by the legislative branch, and then overseeing various components of particularly Supreme Court litigation, but also approving of lower court decisions and challenges that any government lawyers up and down the spectrum want to make in various other courts. They run the Office of the Solicitor General, which is swollen substantially to now be 4 deputies and 17 assistants, and one of whom is in the room with us today. Then they also have an office in the Supreme Court, which is a rather unique component of their position, which has led some people to refer to them, particularly Lincoln Kaplan, as the 10th Justice, because of their particular role and focus and influence in the court. They also have some really interesting privileges, not to get too dirty into this, but one of them is something called they can confess error if they think that a lower court decision was erred. They have a really interesting role in the court where the court will, in instances in which they aren't sure about a piece of law, they will call for the views of the Solicitor General, which basically means that they ask them what they think. And they incredibly often end up agreeing with the SG whenever they come out with a recommendation. And then they can also just decline to defend something if they think that it's unconstitutional. And so that's what's happening now with the Marriage Act that the SG's office has recently decided to not defend. So originally when David and I started looking at this, I was just interested in SGs, but then I started getting interested in former Solicitors General. And so there are 3 basic eras of times in which SGs did unique and interesting things in their time after serving in the SG's office. So the first era is kind of this group from 1952 to 1981 who generally after serving either taught or became a judge or did some other type of public type law practice. They were not involved heavily, if at all really, in Supreme Court litigation after finishing their term in the SG's office. Then there's a second group from 81 to 93 who often became of counsel. We're getting closer. We're doing a lot more litigation after serving, but we're not heavily involved with firm practices. Then from 93 to present, you have a really interesting, and so I haven't updated this for the recent groups, but you have a really interesting thing where all of these folks became heads of some type of national appellate practice, Supreme Court practice, something like that, that was at a major firm that was heavily focused on Supreme Court litigation. And they built big firms and big practices around these folks. And so this was something that I was interested in and checked out before, and the history of it you can see in another paper I wrote if you want to see it. But it's not what I'm looking at today. But I wanted to give some background on it. And this was what really got me interested in this question, was this idea. So blue cases are ones that these folks argued while they were in the SG's office. Red cases are ones that they argued after serving. Now, a really interesting thing is that everyone from almost every SG did not actually work did not actually argue cases in the court before serving as SG. Ted Olson did, 1 or 2 other people may have, but in comparison to the incredible bulk of cases they all have argued after serving, there was a very slight degree of involvement, if any, from these SGs before they actually served. So something is happening there, and I'll get into that in a bit. But this all led me to have 3 hypotheses about post-SG practices. First one is that given the trend, there would be an increase in participation of anyone who's a post-Solicitor General person, whether that's a deputy, an assistant, or an SG from 1980 onwards. Second is that they would have a higher winning percentage, and I'll get into that in a second, but you can sort of hypothesize, given their experience, their relationships, all these other repeat player advantages, that they're going to have a better chance at winning than any other lawyer. And the third one is that if you look at the docket, you can see pretty quickly that there's a tilt of these folks towards representing businesses and corporate interests. So those are the kind of like 3 ideas that I came up with as I was looking through some of these things. And those are the hypotheses that I tested and that I'll be talking about today. A brief note on hypothesis testing to talk about some of the methods that I used. So the real difficult thing, and we were just talking about this, FOIA requests are an incredibly fascinating and difficult and painstaking process to undertake, especially when you're dealing with the Justice Department and the Solicitor General's office. So the basic testing scenario that I set up was, so I crawled OYAS, wonderful site, I'm sure all of you guys use this, for every case from 1980 to 2011 and extracted the information to build a database about how, basically like putting together every type of information that I would need to test. So who argued what cases, whether they won or not, who they were representing. So I used Python for that, and then used Mongo to build a database, and then made a series of Freedom of Information requests to the SG to get their, and the Justice Department and anyone else who would listen, to get a list of veterans of the Solicitor General's office. And so I took that list and built an Excel document and then clashed them together to see whether or not there was a heavy occurrence of folks from the SG's office participating in cases, and you'll see in a moment there was. So that was my basic method. Also, David and the Harvard Law School program on legal profession, again, have enabled everything that I've done here, and I am wildly grateful to them. Anyone have any questions so far? I'm always happy to take questions. All right, so a brief note on an interesting and difficult statistical trend is from 1980 to 2010, the docket has shrunk substantially. And it's also, and if you go back to the founding of the court, it's gone down from the 300s even to be a much smaller docket now. So most years you're looking at 60 to 70 arguments, give or take. And so it makes for an interesting hypothesis testing scenario. But so this is the first hypothesis. So what you have here are a couple different things going on. So generally, you're looking at whether the veterans of the Solicitor General's office have participated more in cases from 1980 to 2011. And so each of these things represents a couple different things. So the black dots across the bottom here represent the actual size, the numerical size of the number of cases that were argued in a given term. And as you can see, that's declining steadily. The top lines represent the actual numerical number of cases that were argued by a veteran of the Solicitor General's office. And that goes up and down. The red dots here represent the percentage in any given year of cases that were argued during that term by a veteran of the Solicitor General's office. The green lines represent standard error across it. And so I used a logistic regression, which is a regression analysis method, to test whether this was a statistically significant increase. The answer is yes. But I mean, more than testing it, you can just kind of look at it and tell it's pretty obvious. So the general trend here is, and you're looking at even into like the 30th percentile, but going from 0 really in the late 80s or early 80s and late 70s all the way up into a pretty consistent trend of there being heavy participation into the 20th and 30th percentile of cases being argued by former members of the Solicitor General's office. A note, some of these numbers may be difficult to verify because just in the way I built the database, I had to assume that there was going to be some type of error around statistical combining of the names. I used a fuzzy algorithmic matching tool in Python still to try and account for that, to match up names, whether there would be things like misspellings or different, like Jim and James or something like that too. But there may be some error, but generally I am confident that it's not, this is not 100% accurate, but nonetheless, it's darn close. Any questions on this? Yes, Sam?
You mentioned that the Solicitor General office increased over the past however many years?
Their participation?
Just the size.
Yes.
Did that increase in proportion to the number of cases argued by alumni?
No, I mean, it's only been, do you know the specific, I mean, I know that the growth hasn't been huge recently.
Incrementally.
Okay.
I mean, there's, 17 assistants now? There would have been 14 assistants, 20, 30 years ago. It's not big.
Yeah, so it's been a pretty nominal growth. Sure. Other questions? Cool. So there's a couple of things here, and I'm not going to get into all of them. And to get into all of them, you should read Professor Lazarus' paper. But why the bounce? Why did this happen? I think there are a couple reasons. So you had this case. The court said that law firms could start advertising, so that means the firms started advertising. American Lawyer and National Law Journal started ranking firms, and so firms become competitive about those rankings because, anytime you put two people up in the line, everyone wants to be at the front. The number of clerks expanded from the 70s from 2 to 3 and then 3 to 4, which made for a larger pool of potential people to fill the ranks of these firms, more people who wanted to practice at the court after serving as clerks. You had Sidley Austin and Rexley built a practice in '85, and Rexley had an incredible amount of success early on, inspired clients to feel like there was an interest and a value in having a specialized expert Supreme Court litigator. And so as a result, you have this arms race. Mayer Brown, Gibson, Dunn, and Crutcher, a couple other firms start trying to snap up former members of the Solicitor General's office and building practices around them. Clerk bonuses were something that Carter Gibson started paying in 1986, so he was giving $10,000 to former clerks. Now I believe that number is at $250,000 as a signing bonus for clerks. And then also just generally the money. It pays well to litigate there. A lot of these firms, the lawyers who are running these firms are pulling down $5-6 million a year, which is more than you make working for the government. And former SGs who I've talked to have openly identified that as a reason why they wanted to get back into the practice. It pays really well. Questions about this?
So one other factor, and you may get to this, but you've already alluded to it, is the increasing willingness of business to use litigation in order to further business objectives, right? So it's both ways. It's both the increasing that. Okay. I know what you're going to say.
So there's another side to that, which David alluded to, and there's a series of compounding factors here. Justice Roberts alluded to this pretty well. He said, one side hires a Supreme Court specialist to present a case. It may cause the client on the other side to think that they ought to consider doing that as well. Generally, you're going up against someone big, you want to tighten in your corner too. There's also been an incredible increase in litigation from a host of different groups over the past 20 or 30 years. And like David said, a lot of them are businesses, specialized interest groups that are increasingly interested in using the courts in a political or policy or some type of method that falls outside of purely that case. They are looking to set a precedent. They are looking to work as a repeat player to establish some type of winning precedent or avoid a sweeping losing precedent for their interests. There's also been a really substantial increase in the number of amicus briefs that have been filed. And that's been actually an interesting compounding factor as well. So a part of this too is there's an incredible statistical correlation between the number of briefs that are filed for a case and whether or not the case is granted cert or not. Every year you have somewhere between 6,000 and 10,000 cases that are coming up from lower courts that people of people applying to the court to get their case granted. So if you're going from that to 65, that's really the much harder barrier to cross than anything else. If you can do anything to help yourself in that game, you probably will. So anyone who's getting above 4 or 5 amicus briefs is really, really likely to have their case granted. And so there's been an increase in interest in filing those. People will go around and solicit NRA, ACLU, these big groups to file a brief on their behalf because it helps them out a lot. Just interesting stat from 04 to 07, nearly 1,000 private organizations, many of them were pro-business, filed briefs at the court. So that's a lot of briefs. Also note that some of these briefs, to get them filed, just one brief can cost as much as $100,000 if you want to get it from a really well-respected litigator or a great firm. I'll talk a little bit more about amicus briefs in a second, but this is the second hypothesis that I had. So this is a comparison of wins for post-OSG and non-post-OSG advocates from 1980 to 2011. The green one is non-post-OSG. Blue is, I'm colorblind. Is this blue? Yeah. All right. So non-post-OSG, you can see. So petitioner generally has a better chance of winning in general The reason being simply that if the court decides that they want to hear the case and is considering hearing it to overturn it, then there's a reason that they're going to hear it. And so the petitioner just generally has a better shot at winning statistically. But you can see that there is a much higher probability of you winning if you are a former Solicitor General or veteran of the office than if you're not. So you're looking at 10% variance and 11% variance. Again, tested for statistical significance. It's definitively significant. Yeah?
What are you doing with the SG cases? How would a case where you've got the SG against opposed SG, how does that fit into your, that's a lot of the cases. How does that fit into your analysis? So you've got the Solicitor General's office on one side, they're not opposed to OSG, going against, Seth Waxman, who's opposed to SG.
I counted them normally.
So what does it mean you count them? So which way?
So I would have looked at that as being so if Waxman won, then it would have been a post OSG win.
So your non-post OSG includes the SG's office.
Yes, I think.
Yeah, that's something you might want to think about breaking out. Because the SG's office by itself is a very significant winning percentage.
Yeah.
It'd be interesting to know how the post OSG.
That is a cool question.
But including the SG's office as your non-post OSG is going to skew your stats too favorable to the.
That's true.
OSG.
Oh yeah, that would actually probably swell it even more.
Well, it would depend, though. I mean, this is tricky, right? Because the SG oftentimes gets involved, depends on which side of the case or whether they're just even not a
They're
party.
about 85% of the cases. They're almost all the cases. So.
But that makes this even more surprising. You're saying, in other words,
Right.
the current SG is in the non.
That's right. I think your stats would be more telling if you break them out a little bit.
That's a great idea. I'll rerun some of those. Thanks. That'd be great. The other thing, and I'll get into this in a second, this is not a black box statistical question here. There are reasons for this, case selection, et cetera, which impacts this beyond just the pure numbers. But this is a general point that I think will hold here, and probably even more if I test it that way, which is a great idea.
What do you do with cases, there are a lot of cases now which have the post OSG on both sides?
In those ones, I just counted it. How did I do this? I was thinking about excluding them.
There'll be a lot of the cases.
It was a lot of the current ones. I just counted it. I counted it 0, 1 either way. And so if it was someone going up against one or the other, if it was a post OSG generally, I just gave them a 1. And then
because you think about that too is hurting things a little bit because this suggests how much better do the post OSGs do in going against non-post OSGs.
Yeah.
And the fact is they're quite often going against other post OSGs, and that's a different kind of issue.
Yeah, I'll split these out. This will be fun. Thank you. Then, so generally here, the repeat player advantage is, I don't have copyright license over these. There are two big types of repeat player advantages that you have going on for people who are post-OSG. One is this idea of whom you know, and the other one is what you know. So for a lot of the folks who are leaving the SG's office, they have been a lot of times clerks for justices. They know a lot of the other folks who are litigating at the court, so they can go around and ask other people to file briefs on their behalf, which increases their odds of getting on. A lot of them, I think I have a, so a lot of cases, so for example, and a lot of them have like personal relationships with the justices. So Ted Olson, for example, has given speeches with current members of the court. 2 justices attended one of his weddings. He's spoken on panels with a lot of these folks. And that's just one example. A lot of them have other interesting relationships and backstories with a lot of them. A lot of them were clerks for some of the current justices, especially some of the younger folks coming out of the SG's office. They've co-argued in prepped cases. Now a lot of these law clinics, inspired by the success of the Georgetown University Law Center, I think, in a lot of cases, argue and pre-argue these cases a lot and do incredible amounts of preparation for the oral arguments. And so a lot of times, if they're arguing a case together, they prep with that justice. So Justice Roberts, for example, while he was a member of the bar, prepped for cases with Ted Olson and Seth Waxman. And so that gives you kind of like another perspective into like their mind and lets you know how they're thinking, and also gives you a relationship with that justice. And then you have this general thing of clerks and reporters and other fellow advocates will trust you more. There's kind of this like renown and respect that goes with having been in the SG's office. What you know is obviously you know a lot about litigating. So they're screening, they're arguing. So they're screening all of these lower court cases that are coming up from the appellate courts. They're arguing lots of cases. So it's hard to measure the number of cases that any OSG is arguing in a given year, because a lot of them serve terms that are stinted, where they'll start or end halfway through a term, and they only serve usually between 1 and 3 years. But usually in their first year, they're arguing between 6 and 7 cases, and that's a pretty steady clip. And that's a lot of cases, especially if you're thinking about they're only 65 a year. Then they're doing a ton of briefing. Just in OT09, I looked it up, and the SG's office filed 30 petitions, 162 responses, and responded to 12 calls for the view of the Solicitor General's office. And so again, it's an incredible amount of preparation, great practice for briefing and running a clinic. So they get really good at case selection. An interesting thing on this is, so SCOTUS blog, a phenomenal legal resource, an excellent place to work, does a set of predictive things where we picked out a brief and guessed whether or not it would get on the docket or not. And typically runs about 80% accuracy. So this is not, again, another black box statistical question. Most of the time, if you know what's going on, and if you're that close to the docket and know what the court is looking at and what's going on, you have a really good chance of picking a winning case. And so that's another part of this question about why would they be so good at getting cases on the docket? Why would they win more often? They probably really know the most important thing about litigating at the court, which is how do you count to 5? So then there's who and what you know advantages. Hoover, Roosevelt, Truman, and Carter all had personal relationships with SGs and worked with them in some types of policy or political senses. Former OSGs will also have a lot of experience managing brief conflict. So they know how to get together different members of the Justice Department and all of these other places and write a brief that can speak for a lot of different groups and folks. And if you want to get people to file an amicus brief on your behalf, you have to know how to do that. They know how to run the OSG, which is in a lot of ways comparable with running a Supreme Court litigation group or clinic. A lot of them have a ton of former clerks. Kirkland and Ellis, 22, Wilmer Hale have 40. And so what better way to do argument prep than line up a bunch of former clerks for justices and run a scenario in which you ask them to speak on behalf of the justice that they worked for. And they have a ton of just general experience arguing, prepping, and advising. So a lot of these folks will not necessarily keep arguing even. They may just provide advice, and that's why a lot of folks will also become of counsel instead of actively litigating, that manage teams where they don't actually have to argue. And there's also kind of like one thing I found while I was doing research about this and while I was working at SCOTUS blog is there is, and I think a very well-deserved respect for the OSG that gives them kind of a halo effect of these are incredibly talented and smart and exceptional lawyers. And for good reason, there's an incredible amount of respect that is given to them. And that doesn't necessarily leave as soon as they walk out of the office. It's something that is maintained. So there have been books written about the SG, there are conferences about them, and when I checked, it was about 70 articles that were written about SG. So there's a very substantial body of research and amount of respect that's allotted to SGs. This is my most recent hypothesis testing, which I am grateful to Kai, my roommate, who hosted me last night as I finished this one. And I apologize for not having a graph. And also thanks to Dick Gross, whose son has been of invaluable assistance to me as I wallow through my statistical questions. This one is so it's a 2x2 test. It's kind of similar to the earlier, prettier graph in the outcome and what I'm looking at. So this one was the trickiest to test, whether SGs are disproportionately representing business interests or not. So the basic way that we tested it was pulled out a sampling of cases of post-OSG, non-post-OSG, respondent, and petitioners. And I just went through and hand-coded them to see whether they were representing a business or interest or not. It ended up being really complicated, much more so than I thought, to decide whether or not someone was a business interest or not. I'm happy to, if anyone wants to look at it, I can send you the chart that I made about it, because I really just kind of like read through it. I use kind of like Potter Stewart, I know it when I see it kind of thing. But basically, in a lot of the cases, it was really clear, though, that they were representing someone, or they were representing a business interest, like corporation, Inc. Like these kinds of things are pretty indicative of a business interest. Basically, the answer is yes, they are representing business interests far more than non-post-OSGs. So you have here, so this is petitioner, respondent being 0 here, and you have the number. So here you have non-post-OSG representation for business. So you have 19 for not and 6 representing business. 14 versus 11 for post-OSG. So the general number that is, I think more interesting, actually, rather than getting to this one, is the overall sampling here. So you have, I essentially rounded across, and you had 42 non-post-OSG, non-business cases, 8 non-post-OSG business cases. For post-OSG, 32 cases of non-business, and then 18 business cases. And so I think most interesting of those ones across there is the 8 versus 18. I'm going to get a bigger sampling, but this was already big enough to get statistical significance across it. But so the general answer to the third one is yes, there is a higher instance of there being folks from the OSG representing business interests. Well, before I go to that, does anyone have any questions? All right. So I would say now a brief view on a brief aside on my views of the justice system. I think that it's disconcerting, and there is a lot of, like I said, there's a lot of statistical noise that goes on here around why folks might win more often if they're from the OSG, how those cases happen, why they would be representing businesses more often, et cetera, et cetera. But it's a little disconcerting that the outcome of a case and whether or not it's granted could be contingent on the lawyer who's representing you. It's an uncomfortable reality, and we all know it's true, but it's just a little, it makes me a little queasy when you think about it. Because you like to think that there's a fair shot for everyone to have an equal shot at balanced jurisprudence, who has an equal shot at winning their case if they in fact have a winning case, and at having an equal shot at having some type of justice. And I think that in this case, I would invoke Joseph Raz, who I think is an awesome authority on this kind of question, because I think there is sort of an outcome here that could work. Because in a lot of these cases, I think you're looking at what inherently comes down to some type of collective action problem, where it's in the best interest of a lot of people to look at and solve this type of problem. And there's a lot of things that you could do to distribute resources throughout. Because a lot of folks, post-OSG folks, are interested in and do a lot of pro bono work. Whether that's at the cert stage, where they're writing a lot of briefs for folks, or whether that's arguing cases. Seth Waxman and a series of Guantanamo Bay cases, et cetera, et cetera. And so these folks would take these cases on, but you can imagine the incredible load that you're shouldering as a lawyer in trying to do research through all of the lower court dockets to figure out what cases you would want to write a petition for. You're already having 6,000 to 10,000 petitions coming in a year, and that's not even accounting for the ones that don't get challenged. So I think there's a couple things you could do. A lot of the law schools have clinics that have resources that they would willingly and do willingly put into pro bono work. And then you have, you could do split arguments, which is a cool idea where you could just allot more time to specialized litigators who would be willing to put forward their representation and their effort on behalf of someone who doesn't necessarily have. Because by the time a case lands and the court grants cert for a case, if you get your case granted, you will have a host of people who will more than willingly represent you. The problem is crossing that threshold. And so that's where I think you can sort of bring in a distribution of different types of research and figuring out how to kind of play this out a little bit. So I think that there are a couple different places that next steps of research could or should happen. The Federal Judicial Center and some of the various committees that are part of it, the American Bar Association have all done big, important, cool research about access to justice. And I think that we could do a lot more. And I think also that it's the type of thing that, Justice Roberts has again and again called for higher judges' salaries and has not at all held back on making policy claims. And the Senate Judiciary Committee has also done a variety of hearings on access to justice things. And I think that looking at this and figuring out ways to distribute access to exceptional advocates would be a really meaningful type of research to do. So how can you figure out, how can you make sure that lower court cases that are deserving of a potential hearing or that would have a chance of getting onto the docket are getting into the hands of the right lawyers who would be willing to do pro bono work? Because it's great for their practice, it's great for their firm, it gives them an exceptional name branding opportunity if they have the case heard, and a lot of them just believe in what they're doing. And they go to the court because, and this is another part of why these firms have built up. A lot of the folks who are in these courts are there for a reason, which is they love the Supreme Court. They love working there. They want to keep working there. They believe in the causes that they're representing. So I think if you can figure out a way to pair up the cases that were deserving of being heard and that have a shot at being heard with the people and the clinics and the groups and all the resources that would make that happen, I think that could be a really meaningful way to address some of the disparity in the access to advocacy and to resources and to the best litigators and advocates. I think it would just be conjecture on my part. I don't, it could go one of the other way, where it could either be that it becomes less and less pronounced because you have a larger and larger pool of former clerks and former OSU. But it's also, the other thing could be that they're become, and this is the case now, there are 10 or 20 people who you constantly see on the docket. And they're there, and they're winning, and they're really good at it. And, it's, and because it's and a number of studies have shown this of clerks, for example, say that they allocate extra attention to, if you're looking at 10,000 briefs a year as a clerk, and you're, no offense, 2 years out of law school, that's a lot of work. And it's very complicated. And a lot of clerks have pretty openly said they look at the name to decide whether or not to grant cert. And, if you're Larry Tribe or Richard Lazarus or one of the other folks here who are regularly practicing in front of the court, it's a great way to get your name in. So it could go that way, or it could go the way that you're talking about, where there's a saturation effect. I don't really know. Well, thank you everyone for coming. It was fun.